Give self-introduction to us.
My name is Sudatta-Aarohan, and I've completed my graduation from SUA National Institute of Law. And thereafter, I've been preparing for judicial services. My hobbies are doing mandala art and cooking, and I belong to Keonjhar, Odisha.
Oh, you are preparing for judicial service.
Yes, sir.
Under which article you will make your entry into judiciary? Can you say?
Sorry,
Appointment
sir.
to judiciary.
Constitutional
That
provision.
lower judiciary is available under what article? 234.
Okay, sir.
234 you will go through.
Okay, sir.
So now want to be judicial officer in initial stage, he will be appointed as a judicial magistrate. Do you know? And civil judge. So what are the different criminal courts there are?
So first is Court of Sessions, thereafter Judicial Magistrate First Class, thereafter Judicial Magistrate Second Class, and Executive Magistrate. The same is dealt under Section 6 of the Criminal Procedure.
No, little bit. You must try to know. So lowest rank, magistrate second class, magistrate
Yes.
first class, then assistant session judge,
Okay.
chief judicial magistrate. In metropolitan area, there are chief metropolitan magistrate and chief metropolitan magistrate, then session judges.
Sorry.
You'll go through. My question is that you must know, we are apprising you and widening your mind. Can you say what are the power conferred on them to exercise?
To the magistrates?
Yes, magistrate and up to district judge. Magistrate is empowered, magistrate first class is empowered to impose.
To 3 years up to 10,000 of fine. Judicial magistrate.
10,000, that is 10,000.
Yes, sir.
Judicial 10,000. Then assistant session judge. Habeas and fine. Chief judicial magistrate. Assistant session judge.
7 years. And the fine.
Fine.
Assistant session judge for 10 years. Session judge is unlimited. However, death sentence has to be done. It has to be confirmed by that of the Honorable High Court.
Then should be confirmed by High Court, and a life imprisonment we can pass. Session judge includes assistant session judge, but additional session judge also.
Yes, sir.
Do you know what is executive magistrate?
Executive magistrates are the parts which are those magistrates which are more of they perform in the preventive action, like in case of urgent cases of nuisance, or there is a under section. There is a conditional order for removal of nuisance. In those cases, they are there. And a judicial magistrate comes into picture once the offense is committed.
Executive magistrates are functioning under the administrative control of the district magistrates cum collector. So the executive magistrates are subordinate to the district magistrate. Okay?
Yes, sir.
As a magistrate, you must be knowing when an offense is committed, people used to lodge a FIR at a police station. What is the duty of a police officer after receipt of the FIR?
Under Section 154 of Criminal Procedure Code, once he gives an FIR, if it is given orally, then it has to be reduced to writing. And he also has the duty to give this informant the copy of the FIR at free of cost.
Suppose your police officer in charge of the police station, IIC, did not register the case, did not hand over a copy of the FIR to the informant. What remedy is available to him or her?
First of all, he can approach to the superintendent of police by writing it by way of post. He can send it. Honorable magistrate can also magistrate can also order under section 156 clause 3 that directing the police officer to register an FIR or a complaint can be done under section 200 of the Criminal Procedure Code.
So, as far you're saying, if police officer or officer in charge did not act upon the FIR, he or she can approach to the superintendent police in writing. On the event of the failure, magistrate shall take step under section 156(3). So whether any complaint is to be filed in my state or my state simply will instruct police.
If there is a prima facie, if prima facie it is seen that cognizable offense is there and police officer is deliberately not doing it, then he will order the concerned police officer that you register the FIR. It's a pre-cognizant stage, basically. So no, much of inquiry or investigation is not done in this text.
Unless a complaint under section 200 CRPC is filed, my state, after either examining the witness or basing on the initial statement of the complaint, can direct the police. Two ways are there for the magistrate. On receipt of a complaint under section 200, magistrate may examine the witnesses and can proceed with the case, or magistrate can direct police under section 156(3) to take up an investigation and to submit charge. Okay. What do you mean by recording of confession by magistrate? Under which provision the confession of the accused is recorded?
By virtue of section 164 of Criminal Procedure Code, basically the confession is recorded by the magistrate. And it is done by either Metropolitan Magistrate or Judicial Magistrate First Class. The duty is that it has to be seen that it is done voluntarily. And in case if he refuses to give confession, then he won't be sent to the police custody. And that is the main, and he has to also read and explain it to the accused that this is the confession that you have made. And also he has to see the demeanor of the accused, that whether he is under any pressure or anything, whether he is understanding the consequences of the confession, that it can be used against him.
So far as the recording of the statement of the accused under section 164 CRPC, the accused should be free from any undue influence. That means there should be no pressure from the side of prosecution on behalf of police. The accused must be in balanced state of mind. The accused must be warned by the magistrate that he is not bound to make a confession. The accused must be informed that if he confesses, it will go against him. The accused should be warned that he can appoint a lawyer on his behalf. If at all the magistrate thinks that he is free from all influences and due free mind, and voluntarily speaks, yes, I will admit, then his statement shall be recorded. Yes, if the magistrate, suppose you are the magistrate, if you feel no, still there is undue influence, his mental stability is they are not available. You can give some time. You can send to jail, then next day or after 1 hour or 2 hours, you can record. After taking all sorts of precautions, and the magistrate will himself say, I am a magistrate. It will admit that it will go against you. Then, being satisfied that he is voluntarily making this statement, the magistrate shall record it. This is the confessional statement. Whether any admission before police is admissible or not.
By virtue of
accused before police is admissible under law.
By virtue of section 27, if there is any discovery of fact,
27 leading to discovery, 25 of evidence
that 25 and 26 it says that confession done to a police officer or in his custody, that is not taken into account. Section 20
confession made before a police officer is not admissible in evidence.
Yes, sir.
What do you mean by leading to discovery?
Sir, by virtue of section 27 of the Indian Evidence Act, it says that in case if if the accused makes any statement, say the use of any weapon or anything he has used in the crime, that he has hidden it in a certain place, and police officer goes and finds out, then that is taken into consideration. However, it is a corroborative piece of evidence and not a substantive piece of evidence.
Leading to discovery means the accused will voluntarily lead the police party to give a discovery of the weapon of offense. Then it is, he will lead the police party. So in presence of that, if recovery is made, that is the leading to discovery. He will lead, the accused will lead police party to give recovery of the dead body, or it may be weapon of offense, like that, anything. What is PI parade?
PI parade is basically it is done so as to ensure that the witness who has given a statement that a certain person have committed a crime. In that case, they are put in a line, and in that respect, it is seen that whether the person is able to identify the accused or not, so that reliance can be placed in his testimony that he has given. It can be of a person, it can be of a thing as well.
9 of evidence may be referred to.
Yes, sir.
Where
Section
it is provided, section 9, where it is provided to identify the accused, suspect, or any property also. Do you know, property, suppose there is theft of earring, theft of watch, like that.
Yes, sir.
So, I will be confirmed that the PI parade is admissible or justifiable, identification is correct. How, as a magistrate, you will feel it true and correct?
There was a certain guideline which I am unable to recollect at the particular name, but it was said that in that particular guideline, it has to be done as soon as possible. There should not be too much of gap that has to be given, because then there will be concocted version of different theories will come into picture, and there has to be a sufficient evidence that there was a light, or what was the eyesight, or what was the current situation there, whether there was sufficient light or not. All these things has to be taken into consideration. I don't remember the exact case name, but it was some guideline that was given.
Anyway, remember that the identification When the FIR is against known person, there is no justification of a TI period. When the FIR is against unknown person and the informant is not able to say who was the culprit, but describes the stature, complexion, height, etc., there is a possibility of in the world there is no similar person. Your face is not similar to me or to anybody. So this is a distinguished feature on the earth that nobody is having resemblance with another or similar to another. So in that case, the philosophy is behind that. If one describes the stature, complexion, if she or he is able to identify the other person, then it is a test identification period. Principle behind it that he must be mixed with similar person of similar stature, similar height, like that, or having some resemblance. If one is able to find out but trace out correctly, then in that PI identification period, it will believe that he or she is able to find out that person who was the culprit. Suppose a donkey took place in my house. I had seen the person, his appearance. I can only describe his figure. And if I am able to find out or trace out that person, when he is mingled with other persons of similar stature, then there is some possibility that my identification is correct to some extent. Though it is not substantive evidence, but it is a corroborative piece of evidence. Do you follow?
Yes.
So what do you mean by examination of witness?
Examination of witness is basically done in 3 stages. First is the examination in chief, wherein the party who calls the witness, he examines and asks some basic questions so that honorable court will be aware about the facts, about the background of the case. And thereafter, the cross-examination is done. It is done by the adverse party so as to ascertain the truth of the facts. And if at all it is required, with the permission of the honorable court, then re-examination is done. In these 3 stages.
So, as per your sayings, examination in chief, cross-examination, re-examination.
Yes,
Whether can there be a re-cross-examination?
I won't be able to answer this.
The natural, for the end of natural, suppose X witness is examined, gave some witness, he is cross-examined. Let us say the prosecution found that he is to be examined to give some other new evidence. When you are giving some scope to the prosecution to examine, to adduce further evidence, the witness must be cross-examined in that light. Otherwise, that his evidence will be gospel truth.
Okay.
So, in order to gain truth or to get justice, the witness must be subjected to further cross-examination. Okay. What do you mean by contradiction?
Contradiction in relation to?
Relation to. So, you're saying that the witness is examined.
Yes, sir.
He is to corroborate the case of prosecution past dates.
Yes.
Informant has lodged FIR. He is examined on behalf of prosecution. It means the witness will describe the prosecution story.
Yes.
That amounts to corroboration. The earlier statement submitted. What has been written in the FIR? What has been recorded under section 161 or 62 by police? Those statements are to be corroborated by the witness while giving evidence in chief.
Yes.
Understand?
Yes.
Then, in order to ascertain the truthness of its veracity, the witness is to be subjected to cross-examination. True. By doing the cross-examination, the defense has to ascertain the truthness, how far the witness is a truthful witness, how far his evidence is accepted. Suppose the witness for the prosecution did not support the case of prosecution. He had stated something earlier. Now in the court, no, I do not know anything. In that case, prosecution declares him hostile.
Yes, sir.
Under which provision he is declared hostile?
Under section 154 of Indian Evidence Act.
It means what is the object? Why is he declared hostile? What is the object?
Because he no longer serves the party who has called him, so he is declared.
No. While a cross-examination, once in chief he stated that I do not know anything about the occurrence. Now the prosecutor will ask her that you are a relation of X, a relation of acute, so you are suppressing the truth. Or you are having enmity with the person who was assaulted. You are speaking liar or suppressing truth. And he will ever the court that due to his interestedness for the defense, he is suppressing the truth. Says my hostile declare for what reason he is not saying the truth? As a magistrate, have you any power to interfere in the examination or cross-examination?
They are free to ask any question that they want. And if there is any indecent and scandalous question.
At what stage court will interfere? Will put question?
The trials.
Section 165. In suppose defense or prosecution is putting complicated questions, the witness is unable to understand, ambiguous questions.
Yes.
In that case, court will know he is a simple villager, village lady. You put simple question. So by threatening, by making her fear, so don't use that means. The witness must be put simple question. He should understand the question. Otherwise, how he or she will give the correct answer?
That's true.
So, in order to give true justice, as the magistrate, you are to interpret in the proceeding. You must try to listen the truth. How? Thank you. Wish you best of luck.
Thank you, sir.
पढ़ापढ़ी करो, है ना?
Thank you.
कोई तो कहते तो पाउच के तो कोई दियो हां रेटिंग देखो आपण पड़ते हां रेटिंग कोई दियो सजो
नेक्स्ट के जगह ला शेयर है ना
अब नहीं को ये जीव रेटिंग के दो
आपकी शेयर है ना कोई
दो तो हां तम रेकॉर्ड कर दो कोई तो कहते
65%
नो 65 ये जेरा ना वाला कोन
जे गला
हां ता ना कोन